Hello, everybody. It's Roger Royce, I'm partner at Haynes Boone and host of the 10,000 Startups podcast. And today I want to talk to you about the end of Chevron deference, Loper Bright versus Raimondo, and the recent Supreme Court decision. Now, I particularly want to focus on its impact on startup companies because this is a startup law podcast. And you might think, gee, that's awfully technical. That sounds very legalistic. Why do I need to know about that? So let me give you the 20-minute high level as to why this is a sea change. This is a massive development in the law for a lot of companies if you are in a regulated space. If you have anything to do with FDA approval, um, if you're taxable, you might impact IRS regulations that may have applied to you before. If you do anything in climate or energy, it might impact EPA regulations that apply to you, FTC, anything that's regulated. If you're life sciences, if you're agriculture tech, anything that really, or even if every company is regulated by the SEC that sells securities, and it might impact that. So this could have massive impact on you, especially as it relates to something that startup companies are always fighting against, and that is the concept of regulatory capture or regulatory exclusion. The idea that the established dominant players in a market can keep their smaller competitors out just because it's too expensive for a small startup company to go in and get the regulatory approvals they need to get into the market. So let's talk a little bit about the case. At a high level, up until this case, and since 1986, I believe, the Reagan administration, the law was Chevron deference. And Chevron deference means that courts would basically defer to agency interpretations of ambiguous law. So if a statute was silent or ambiguous with respect to an issue, the regulatory agency would fill in those blanks. And if it were silent or ambiguous, the courts would defer to the regulatory agency's determination. That is no longer the law because the Loper Bright decision now says, wait a minute, determinations of law are the province of the courts, not of executive branch administrative agencies. Now, we'll be impacted, we'll consider what the agency, since they have special expertise in an area, might determine, but we're not bound by that, and we certainly don't have to defer to it. That's it in a nutshell. The specific case involved the Administrative Procedures Act, and the court specifically held that the APA requires courts to determine issues of law. It doesn't require a court to defer to questions of law to an agency. And if a statute's ambiguous, well, that is almost by definition a question of law, not a question of fact. The facts in that case, I don't want to dwell on them because they probably apply to maybe hardly anybody that's listening to this podcast. But basically, it was a case under the National Marine Fisheries Service, created pursuant to the Magnuson-Stevens Act. Okay, I even had to read that because I don't deal with that sort of law. But basically, the regulatory agency had to figure out a way to prevent overfishing. That was their charge. They decided to put inspectors on fishing boats and to charge the boat for the cost of the inspector. None of this is in the statute. This is all determined by the agency. So the statute's silent on how they go about it and whether you could charge the fishing boats. And it's pretty expensive, like $750 a day or something like that. So that regulation was challenged, and that's where the court had an opportunity finally to take up Chevron deference. Now, it's really interesting. This is really very much a policy decision. And one of the shifts here is who gets the upper hand in making policy, because what administrative agencies do quite clearly, just look at what the National Labor Relations Board has been doing, look at what the FTC has been doing in non-compete agreements. Look at what the FDA has been doing. These are all very much policy-driven decisions, and they change from administration to administration. So when this Chevron case was decided, the policy shift is that we had an agenda, an executive branch agenda that was intended to give more freedom and less regulation to American businesses, but the courts were restricting that. So at that point, the policy objective was, let's have the administrative agencies get more of a say in this and not have the courts keep upsetting what we're trying to accomplish. Well, now that's all changed. Now we've got an executive branch that is very much restricting what businesses can do, EPA, FDA, IRS, et cetera, and taking more of a restrictive approach and what some of us would call a pro-regulatory exclusion approach. And the courts, which have now grown more conservative, would probably take a different approach, would probably find a different view of the law. So in one sense, this is really a policy shift. We're moving the policy determination from the executive to judicial. No one's going to say that out loud, but really that's what's happening. Now, what does it mean for you, the startup companies? And again, I am not going to get bogged down into the details of the Administrative Procedure Act or the separation of determinations of law, determinations of fact. If you want to know about that, go read the opinion. I've read it. It's quite interesting reading. Instead, I really want to talk more about what this means for you as a practical matter. Life sciences companies. So there are several life sciences cases, FDA regulations in particular, that were decided in favor of FDA regulation based on the concept that the statute was ambiguous or silent. Well, those are subject to being revisited, I think, or at least future regulations are in that space. So we might see a lot of regulations being revisited as a result of this. But one big one, the one that really kind of jumps right to the front of the line for me, it's top of my mind anyway, is the very recent FDA regulations on laboratory developed tests. So the FDA, it's a long story, but in a nutshell, the FDA is proposing to regulate lab tests, which are not subject to FDA approval now. They're just lab tests, to regulate them as medical devices, right? So the FDA can regulate drugs, but they can regulate devices. So lab tests fall outside of that. So if you go down and get a liquid biopsy or a blood test that tells you this, that, and the other thing, that has not been subject to regulation as a drug or a device up till now. Well, the FDA is proposing to do that. That has already been challenged in court in Texas by the American Clinical Laboratory Association under the APA, the Administrative Procedures Act, but it seems to squarely fall within this new Supreme Court test. So, which means that now the court can interpret whether a lab test is a medical device or not. Kind of reminds me a lot of a case I remember from law school, a spoof case where some court had argued and had ruled, this is all made up, but the reasoning was just so indicative of what some activist courts will do, had ruled that horses were subject to the Small Birds Act because, they're pretty close to a bird, depending on how you look at that definition. This is the same thing. We're going to have courts making this decision now instead of regulatory agencies. IRS, many regulations now maybe are going to be subject to reinterpretation or rechallenge, because in the tax space, we are constantly talking about Chevron deference, because the IRS has generally had a very broad sort of, let's say, discretion and we don't, in fact, I don't think we even have to get into this distinction between legislative regulations or procedural regulations. It's going to come down to really, is the silent statute or ambiguous? And if so, then the court will decide what the rule of law is. Again, I mentioned agriculture. It's Department of Ag. That's a lot of different departments. That's EPA, mostly EPA. And that's some FDA. Agriculture touches a lot of different federal agencies, but I think it's going to be mostly EPA. Now, we've seen over the years cases where the EPA rules, especially things like, gee, you can't let your cattle use that watering hole because you might interrupt the geese that are flying south or whatever it is. We've seen rules like that get set aside as arbitrary and capricious. Going to be a lot more rules, I think, that are going to be subject to this sort of set aside. Now, this is probably, and then FTC, of course. What's this going to do with our new non-compete rule? There's no statute that references this. What's the court going to do with that? This is all just kind of open for grabs. Now, the critics of this law of this new ruling, Loper case, Loper Bright, would say, gee, this just opens the door to rejecting all of these protections of the public that our administrative agencies have put in place. The EPA protects us from harmful environmental practices. The FDA protects us from harmful, I guess, medical or drug device practices or products. And this just opens the door to that because we're going to throw that out. Well, not exactly. I mean, what we're saying is that this is now just, the courts are not going to just completely throw out the technical and skillful determinations of the agencies. And to the extent that those are questions of fact, I think the courts will defer to that. It's just that what are pretty clearly questions of law and what Congress intended are now going to go to the courts. We've sort of had that before. You might remember something about the Reins Act, where the court, which I don't think we really even needed. I think Congress has always had the power to go in and they've done this recently, reverse or change administrative rulings. So it's always been sort of out there, but this really makes it part of the Supreme Court law of the land. SEC jurisdiction, probably the thing that is most relevant to most startup companies, whether you're life sciences or artificial intelligence. That's another one that we've been hearing a lot about, possible regulatory restriction and statutory restriction. But getting back to SEC, the Supreme Court has, for a while now, been pretty hostile to SEC interpretations. In SEC versus Jakisi, not pronouncing that right, I'm sure, maybe it's Jakesy, the court struck down a statute that allowed or authorized the SEC to get civil penalties in administrative determination. The court said, look, if you're going to impose civil penalties, then they have a right to a court hearing in a court, an Article III court, and maybe even a jury trial. So, big loss for the SEC already. And similarly, FTC, Axon Enterprises versus FTC, and this is a unanimous court that held that that allowed a constitutional challenge to administrative proceedings, saying, look, they have a right in that case, in those set of facts, to go before a federal court. So there's been some erosion of the administrative state, even before the Chevron case, the Loper Bright case came along. Okay, now, before I get too exuberant about the end of the administrative state and the power and rise of the startups and the diminishment of regulatory capture and regulatory exclusion, which is the idea that major market, think about that. Why do major companies that have most market share go into Congress and say, please regulate us? Do they really want to be regulated? I think maybe, or maybe they just want to keep the smaller, scrappier companies out of their market so they can maintain their position of dominance, because a startup can't afford to comply with regulations. So, but before I get too exuberant about the end of all that, let me tell you there are some limits to this case. So, number one, these only affect rules that are based on statutory ambiguity or silence. So if Congress is not ambiguous, or if Congress does actually speak to a particular issue, the court's stuck with that. That is the law of the land. Second, it's not going to, unlike what the critics are saying, completely end judicial deference to fact-finding, right? Because the courts are going to, I think, they're going to exercise fairly minimal review of certainly of findings of fact, and we'll only set it aside if it's really unsupported by the evidence. And that's a pretty tough standard. So don't worry if, don't worry that the court is going to suddenly become a scientist, because, that's just not what this case says. Importantly, if the agency has been given the power, remember I was saying about tax regulations, if the agency is given the power, and you see that in tax statutes all the time, the IRS shall adopt reasonable regulations to implement the above. If Congress gives the agency the power, well, this case doesn't affect that power, that grant of power. So the agency will still have the authority to make those determinations. That's going to make for some very interesting case law on tax regulations. And finally, just because a court upholding of a regulation was based on Chevron in the past doesn't automatically mean it's going to be overruled or overturned because of this decision, because we still have this thing called stare decisis, and that is the power of precedent. And you can see people making arguments that, look, we've been relying on this for so long. This is the law for policy reasons. We should not upset that even under this new standard. So those are the limits. And at a high level, I just will say that I think this is good news for the startup community. I think it's unfortunately it's good news for litigators and lawyers, because certainly more stuff is going to go before courts to be determined, where otherwise we might have just said, the agency's going to win, so why bother? But it's something that we ought to definitely keep an eye on, because this is really, like I say, really a sea change. I mean, we've seen recently the FTC adopt a non-compete rule, which has been enjoined in one small court, by the way, but nevertheless, they adopted it. A non-competition rule for certain employees. We've seen a independent contractor versus employee rule at the Labor Department level. And we've seen a movement towards adopting a national classification of employee standards similar to Californians at the national level. So we've seen, and this is all done administratively, none of this by statute. So we've been seeing an expansion of executive powers over the last 4 years. And I'd say this case kind of puts a lot of that back into the hands of the court. Okay, this is Roger Royce with the 10,000 Startups podcast, and we'll see you next week.